India Legal presents Courts Roundup.
Hello, I am Taneja and you are watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. Before we begin, here are the headlines. Supreme Court stays Andhra Pradesh High Court's order to examine breakdown of constitutional machinery in Andhra Pradesh, terms the order as disturbing. Supreme Court says that selective leaks to media affects rights of accused and victim, can be used to derail the administration of criminal justice. Supreme Court decides to proceed with the criminal contempt of court case against Kunal, Kamra and Rachita Taneja for their tweets, issues notice. Supreme Court grants relief to 5 West Bengal BJP leaders against coercive actions of state police, issues notice to the West Bengal government on a plea to transfer the probe.
India Legal presents Courts Roundup.
Supreme Court has stayed Andhra Pradesh High Court's order to examine the breakdown of constitutional machinery in Andhra Pradesh. The top court has termed the order as disturbing. The state government has challenged the order, contending that it is the president who is empowered to go into question of breakdown of constitutional machinery under Article 356 and not the judiciary.
An Andhra Pradesh High Court order seeking Y.S. Jagan Mohan Reddy government's response on whether there is a situation of constitutional breakdown in the state is disturbing, the Supreme Court said and stayed the order. The Andhra Pradesh High Court, while hearing over 14 habeas corpus petitions filed by detained individuals, had on October 1 to come prepared to assist the court as to whether in circumstances which are prevailing in the state of Andhra Pradesh, the court can record a finding that there is a constitutional breakdown in the state or not. The Andhra Pradesh government approached the Supreme Court challenging this order, contending that it impinges the doctrine of separation of powers since it is the president who is empowered to go into question of breakdown of constitutional machinery under Article 356 and not the judiciary. In any case, have you seen an order like this as an apex court? We find it disturbing. Issue notice state. List immediately after vacation, a bench headed by Chief Justice of India S.A. Bobde ordered. Article 356 of the Constitution deals with failure of constitutional machinery in a state. The AP government has submitted that this is a power exclusively vested in the executive and cannot be exercised by the judiciary. The petition states that under the constitutional framework, it is not for courts to decide as to whether there is a constitutional breakdown in a state. The plea states that the government had filed an application before the High Court to recall the order under which such question has raised suo motu, but it was not being taken up. Question framed by the High Court is not only unprecedented but is also uncalled for, violative of the basic structure of the Constitution, and it is the most respectfully submitted, grossly misconceived, reads the appeal. The Y.S. Jagan Mohan Reddy government has been involved in an open battle against the state's High Court. Reddy had even written to Chief Justice of India S.A. Bobde, alleging that former Andhra Pradesh Chief Minister N. Chandrababu Naidu is using the High Court to destabilize and topple his democratically elected government. The letter had also alleged that a sitting Supreme Court judge was using his influence in the Andhra Pradesh High Court to achieve the same object. Bureau Report.
Supreme Court has said that selective leaks to media affect rights of accused and victim. The case relates to transfers dowry death case to CBI. While Supreme Court acknowledged the media does have a legitimate stake in fair reporting, the court stated that media leaks can be used to derail the administration of criminal justice.
A Justice D.Y. Chandrachud lead bench of a Supreme Court had observed that selective divulging of information to media or media leaks can be used or derail the administration of criminal justice. The court made the observation while setting aside the anticipatory bail granted to the in-laws of a deceased woman in a dowry death case, while also transferring the case to the Central Bureau of Investigation. The bench of Justice Chandrachud, Indu Malhotra and Indra Banerjee also observed that there is no embargo on a Supreme Court from transferring an investigation to the CBI even after the charge sheet has been submitted by police. The Allahabad High Court had earlier granted anticipatory bail to the parents-in-law, brother-in-law and a sister-in-law of a deceased woman who were accused in the dowry death case. The High Court observed that the FIR prima facie appeared to be engineered to implicate the application and there is no correlation between the various allegations levelled in the FIR. However, the bench pulled up the Uttar Pradesh police for its investigation, commenting that the same leaves much to be desired. The Supreme Court said that the selective disclosure to the media affect the right of the accused in some case and the right of victims and families in other. The court further held that the investigation officer has a duty to investigate when information about the commission of a cognizable offence is brought to their attention. The court added that neither the victim nor the families have a platform to answer the publication or narrate details about their lives and circumstances. The bench further observed that the conduct of investigation authorities in this case, from the stage of arriving at the sense of occurrence to the filing of the charge sheet, do not inspire confidence in the robustness of the process. As such, it directed the transfer of further investigation in the case, invoking powers under Article 142 of the Constitution. Bureau report.
The Supreme Court has issued show cause notices to stand-up comedian Kunal Kamra and cartoonist Rachita Taneja on separate petitions seeking initiation of contempt of court proceedings against them for allegedly denigrating judiciary and judges. The bench noted that Attorney General for India has granted consent for initiating contempt action against the comedian.
The Supreme Court has decided to proceed with the criminal contempt of court case against stand-up comedian Kunal Kamra and cartoonist Rachita Taneja for their tweets criticizing the top court. The top court issued notice to both Kamra and Taneja but dispensed with their personal appearance. The order was delivered by a three-judge bench comprising Justices Ashok Bhushan, R. Bhushan Reddy and M.R. Shah on a slew of contempt of court petitions filed against Kamra and Taneja. On November 12, Attorney General K.K. Venugopal had granted permission to initiate contempt of court proceedings against Kamra based on complaints from various law students and lawyers who had drawn the attention of the law officer to 4 tweets by Kamra. According to the Contempt of Court Act 1971, a private individual can file a contempt of court petition in Supreme Court only after obtaining the consent of the Attorney General or the Solicitor General. Similarly, consent has to be obtained from the concerned Advocate General of the state when filing a contempt petition before a High Court. The background of those tweets was an order passed by the Supreme Court granting bail to Republic TV Editor-in-Chief Arnab Goswami. The Attorney General maintained that the 4 tweets by Kamra were not only in bad taste but clearly crossed the line between humor and contempt of the court. Thereafter, a fresh letter was addressed to AG seeking action against Kamra was based on another tweet. The complainant, Anuj Singh, an advocate at the Allahabad High Court, claimed that the tweet had gone viral and brought disrepute to the institution of the judiciary. Similar consent was granted by AG in a plea against Taneja by a law student, Aditya Kashyap. Kashyap in his petition stated that tweets by Taneja on her Twitter profile, sanitary panels, has threatened the very existence of the Supreme Court. Bureau report.
5 BJP leaders from West Bengal secured relief from Supreme Court against the West Bengal police in connection with various cases registered against them. A bench of Justices Sanjay Kishan Kaul, Rishikesh Roy and Dinesh Maheshwari ordered that no coercive action should be taken against Arjun Singh, Kailash Vijayvargiya, Pawan Singh, Saurav Singh and Mukul Roy, and also issued notice to the West Bengal government on a plea by leaders to transfer the probe into the cases to an independent investigating agency. The leaders approached the Supreme Court alleging witch hunt by the West Bengal police at the behest of ruling Trinamool Congress party. The leader petitioner Arjun Singh, who moved the court through advocate Avantika Manohar, stated that right after he resigned from Trinamool Congress, he was slapped with 64 cases by the Bengal police without any preliminary inquiry. The plea stated that the purposive prosecution carried on by West Bengal police against Singh has denied him of liberty without following the due process of law. A sixth petitioner, Kabir Shankar Bose, had also moved the court, but the bench did not issue notice on his plea. Instead, the court called for a report from CISF, which is currently providing security to Bose. The Supreme Court has stayed an order of the Karnataka High Court which had directed the Bruhat Bengaluru Mahanagar Palika or BBMP elections to 198 wards should be announced within 6 weeks. A bench headed by Chief Justice of India S.A. Bobde also issued notice to the State Election Commission and the original petitioners before the High Court, M. Shivaraju, Abdul Wajid and Ravi Jagan. The High Court had on December 4 upheld the validity of Karnataka Municipal Corporation Third Amendment Act 2020, which had raised the number of wards in Bengaluru city from 198 to 243. The amendment was challenged before the High Court, which upheld the same, but held it that it will not apply to elections of those corporations where elections had become due prior to the coming into force of amended provisions. In the plea filed through advocate Shubhranshu Padhi, the Karnataka government has said that High Court has asked government to proceed the elections in 198 wards despite the fact that Amendment Act increased the wards to 243. In other words, the High Court has directed the state to conduct elections in a manner which is contrary to validly and unanimously enacted piece of legislation, the petition states. The Allahabad High Court has opined that individual name of a person is a facet of the right of expression, which was guaranteed under Article 19(1)(a), read with Article 21 of the Constitution of India. Justice Pankaj Bhatia held, the freedom of expression as guaranteed under Article 19(1)(a) includes within its sweep all forms of expressions, and name in the present world is clearly a strong expression. The court was hearing a petition filed by one Kabir Jaiswal, who appeared in the class 10th and 12th exams conducted by Central Board of Secondary Education, Delhi, with the name of Rishu Jaiswal. Later on, he got a notice published in the Gazette of India intimating his intent to change his name to Kabir Jaiswal. It was claimed by the petitioner that his name was changed in the Aadhaar card and PAN card in pursuance to the Gazette notification. However, when he moved an application for a change of name in his school certificates granted by the CBSE, his application was rejected on the ground that particulars of the school records did not show the same. The High Court rejected the CBSE's argument that two rules cited did not permit a change of name in the present case. Furthermore, the court remarked that right enshrined under Article 19(1)(a) of the Constitution of India, being fundamental rights, could be taken away or restricted only in accordance with the procedure prescribed under Article 19(2). In view of the judgments of the Supreme Court, it was held that CBSE rules could not be considered to be law for restricting the rights enshrined under Article 19(1)(a) of the Constitution of India. Anticipatory bail can even go on till the conclusion of the trial, Allahabad High Court stated. The Allahabad High Court recently held that anticipatory bail can be granted even after charge sheet in the criminal case has been filed. This decision was given by a single judge bench of Justice Siddharth on 8th December in a pre-arrest bail plea filed by one Adil, a law student at Aligarh Muslim University who had been booked under sections 307 and 504 of the IPC. The court, in its decision, cited the case of Sushila Agarwal versus State and held that anticipatory bail need not be in place for a limited duration of time. In many cases, it can even go on till the conclusion of the trial. The High Court's power to grant an applicant anticipatory bail doesn't conclude after the submission of the charge sheet. The bench quoted from Sushila case, which stated that if the facts of the given case make the applicant entitled for grant of anticipatory bail, even after submission of charge sheet against him and the cognizance of the same by the court, the second anticipatory bail would be maintainable before the High Court even though the applicant was earlier granted anticipatory bail till the submission of charge sheet by the High Court. Government officials should not to be allowed to undermine the constitutional jurisdiction of the High Court, emphasized the Madras High Court while pulling up a Labour Commissioner for failing to comply with its earlier order, apart from his empty apology. The High Court admonished the Commissioner for the hollow apology tendered over his allegedly errant conduct, observing, the apparent contempt of court came to light earlier this month when Justice V. Parthiban found that an order had been passed by the Commissioner directly questioning the authority of court by relying on an irrelevant decision of the Supreme Court. This amounted to committing a blatant contempt of constitutional jurisdiction of this court, Justice Parthiban said. While directing the Commissioner to explain his conduct, the affidavit filed by Commissioner apologizing for his error did not find much favor with the court, which opined that same contains cliched, trite and commonplace expression of apology, accompanied by the usual mundane, deferential verbalisms not intended to convey true sense of regret for his crafty transgression. The affidavit prompted the judge to muse that it is time that court act strictly against such contemptuous actions. There was no occasion for the official to claim that he was not aware of the order of stay that he had disobeyed. An irrelevant Supreme Court judgment was pitchforked by the official into this issue. The official cleverly and conveniently misunderstood its import and applied it to a matter that concerned service jurisprudence. The Madras High Court has passed an interim order banning the sale of edible oil in loose packets in view of concerns that such oil is being widely adulterated. The bench of Justices N. Kirubakaran and B. Puglendi passed the order on a PIL seeking directions to ensure that edible oil being sold complies with the standards put in place by the Food Safety and Standards Authority of India. After hearing submissions for the petitioner by senior advocate Veera Katharivaran, the court held, since the learned senior counsel has made out prima facie case that the edible oils sold on loose are mostly adulterated, it would have serious consequences on the health of consumers, and there is a specific provision under the food safety regulations prohibiting sale of edible oils on loose. This court is satisfied to grant an interim order. Accordingly, there shall be an order of interim injunction directing the respondents not to allow in any way the sale of edible oil as loose oil. Terming the data before it concerning the adulteration of edible oil as shocking, the court has also opined that those involved in such adulteration, including manufacturers, distributors and sellers, should be punished as gundas under the Tamil Nadu Gundas Act 1982. The court took a serious view of submissions that the liquid is known to adversely affect the autonomic nervous system. The bench took note that this provision has been taken advantage of food adulterers, as the state has permitted the sale of edible oil in loose packets, even though it has not assigned any reasons for doing so. An affidavit filed by Communist Party of India, Marxist Party, highlighting their fundamental right to protest, rubbed Karnataka High Court the wrong way, with the court expressing its strong disapproval at the tenor and contents of the affidavit. A division bench of Chief Justice Abhay Srinivas Oka and Justice Vishwajit Shetty remarked that affidavit gave an impression that the court was trying to impair the fundamental rights of the party to hold protests and rallies. The court was hearing a plea alleging that national directives for COVID-19 management, part of the Union Ministry of Home Affairs guidelines, were not being followed in Karnataka. The affidavit was filed pursuant to an order of the court during the previous hearing asking various political parties whether they were willing to issue instructions to their members or followers to abide by rules regarding wearing of masks and social distancing at political parties and gatherings. We strongly disapprove of this. Just because you were asked to file an affidavit, you can't deliver such sermons, the court remarked after perusing CPIM's affidavit. Further, the court in its order also observed that it failed to understand why the state government had not levied fines from the organizers of rally conducted on December 5. The court directed the Commissioner of Police to file an affidavit detailing the reasons for not collecting fines from the organizer of the rally. He was further directed to explain why criminal law has not been set in motion against persons violating social distancing norms and wearing masks. That's all for Courts Roundup. Keep watching APN.
India Legal presents Courts Roundup.